What is a motion to suppress in Oklahoma courts? I'm Tulsa attorney James Wirth, and that is the question that we have. In the practice of law, there's various pleadings that we use as tools to get various things done. If we're talking about a motion to suppress, we're talking about in a criminal case where the government is filing an action to try to get you potentially thrown in jail, convicted of a misdemeanor or felony, something along those lines. But everybody has constitutional protections so that we can try to keep the government, whether that be prosecutors, law enforcement, whatever, acting like they're supposed to be acting. So a motion to suppress is where you're alleging that certain evidence should not come in to your case because of bad conduct or illegal contact by law enforcement or elsewhere. So it's you requesting that certain things be not allowed to be brought into evidence. Where we normally see this is going to be in Fourth Amendment violations. So if you have a traffic stop, then there's got to be reasonable suspicion to pull you over. If they're going to search the vehicle, there's got to be probable cause to search unless you consent to it. So if those rights are violated and ultimately evidence is found that they want to use to convict you of a crime, you're going to want to file a motion to suppress. You're going to want to allege that your constitutional rights were violated and that the evidence found is fruits of the poisonous tree, which means that, but for that bad act, it would not be found. It is a consequence of that. And because that act is bad, everything attached to it is bad, which means the evidence is bad and it should not come in. So the formal way to make that request is by filing a motion to suppress in your court case. And you'd want to get a ruling on that before it goes to trial so that you can have proper trial strategy. Many times when these are filed, the evidence that was obtained, if it is excluded, means that there is insufficient evidence for the case to move forward. So it can often result in the dismissal of your case if the motion to suppress is granted. However, these are not automatic. We've seen a lot of pushback in the last, say, 20 years with our Oklahoma Court of Criminal Appeals, where they have been more lenient on the state and law enforcement in this regard. The whole purpose of the motion to suppress and keeping this evidence out is punishment for bad acts by law enforcement. And they're finding that punishment isn't always needed under these circumstances. And there's a case, the Leon exception, that says, well, if the officers were acting in good faith, then there's no need to punish them because of that, which means that even if your rights were violated, sometimes the courts are saying the evidence can still come in and be used against you. So these can be complicated circumstances, but as far as what a motion to suppress is, that's what it is. And if you need one for your case, you're probably going to want to talk to an attorney privately and confidentially to receive more information on that and how it can be used potentially for you. To get that scheduled, a consult with my office, you can go online to makelaweasy.com.